So I got a little story I want to tell y'all, and it goes like this. A fictional story. Most of the names are fictional. Of course, the story is embellished because, it's fictional. April of 2022, disgrace of a crooked-ass prosecutor, Matt Walker, miserably lost in a interview process for magistrate judge to a fat-ass, bitch-ass Sarah Mayhew. And he has never been the same since. His little balls have shriveled up and he's scarred for life. Now, of course, sackless Matt is a fucking crybaby, and so Sarah Mayhew has always felt a little bit sorry for the son of a bitch. Now, mayor and council felt bad because Matt Walker has been suckling at the teat for so long and been a government parasite and trying to get this position for so long that they took some judges out of retirement to give him like a squad of corrupt people to help him out and be a pussy. Other points of business that day that Matthew Walker lost his ball sack were to reappoint Judge Riojas and Judge Cranshaw, take them out of retirement and throw on the calendar for November of 2023. Fast forward 2 years until May of 2024. Some time passes and Matt Walker, the ex parte animal, lays dormant for a little bit. Then is reawakened in May.
Badge number 48098.
What was the lawful reason that you ran the plate of this car based on a photograph from that gentleman at the O'Reilly?
Now, Matt Walker's wife already has a borderline personality disorder, and she has been watching Matt treat these victims like royalty. So she has been stewing in the back, right? And she's now a part of Lane Myers' live streams, but she just hides there, doesn't mention anything, doesn't leave a comment, and she just watches in the dark, probably. And she just wants to be a victim so bad, you know what I mean? So slowly she's coming up with her plan at this point in time, but we'll let the video keep going.
The lawful reason that I ran the plate?
Yeah, I'm calling right now to make a report on you.
Disorderly conduct.
Disorderly conduct?
Mm-hmm.
You got it on video?
Yes.
You do?
Yes. May I see your license, please?
Disorderly conduct on private property?
Mm-hmm.
So that authorizes you to come out to the county and drive past somebody's house?
Yes.
Under what probable cause?
I don't need probable cause to drive around on a public road.
So what reasonable suspicion did you have to run the plate to come by the house, is what I'm saying?
I didn't have reasonable suspicion. I had probable cause that a man dressed like you, wearing this shirt, who looks like you, drove away in this vehicle after committing a disorderly conduct crime.
Are you going to be able to testify under oath for that?
Yes.
My wife's an attorney for the federal government.
No, she's not. She's a law clerk. I looked her up. The Googler is actually pretty fascinating.
Hey, you looked her up?
The Googler, yeah.
What lawful reason did you have to look her up?
It's open source information. I'm allowed to type somebody's name into Google.
So you ran her plate and then Googled her?
Yeah.
Okay.
Fast forward another month until June 4th.
You come in this way, sir. Sir?
Sir, you've been asked to leave by the mayor.
No, I haven't.
Go. Yes, you are.
Hey, city attorney, if they can clap, I can boo. Get your mind right.
The mayor asked you to
The mayor don't have that authority.
Yes, she does.
No, she doesn't.
Yes, she does.
You have one chance.
Thank you.
Get up and leave.
Go.
Or what?
I'm going to arrest you for trespassing.
Attorney, if they can clap, I can boo. Get your mind right.
The mayor asked you to
The mayor don't have that authority.
Yes, she does.
No, she doesn't.
Yes, she does.
You have one chance.
Thank
Get
you.
up and leave.
Go.
Or what?
I'm going to arrest you for trespassing. Let's go.
You're gonna arrest me for trespassing?
Yes.
Then do it. Let's
Disrupting
go.
this meeting.
Come outside and give me the ticket. Let's go. Come on, give me the ticket. Rankin, you'll see the lawsuit tomorrow with. Don't touch me. Do not touch me.
And those are the magic words. Activate, plan, corrupt government. Dun, 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 dun. Matt Walker and his friends. Dun, 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 dun. Ignore all the phone calls in the beginning. Dun, 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 dun. Don't give him the police report. Dun, 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 dun. Call the victim to witness. Dun, 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 dun. Call the witness to the victim. Dun, 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 dun. Hide the police until dun, 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 dun. We have to arrest him because he's gonna question them. Dun, 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 dun. Dun, 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 dun. Realize that Lane Myers is gonna make us look stupid in court. Dun, 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 dun. Then talk to my wife and see if we can get her to lie a whole bunch and put him away forever. Give it 1 week, and here is the backup plan. This came out June 11th. All right. Now, this involves one judge being appointed and 4 commissioners. 6 days after Myers was arrested, right? Now, we have names such as Tracy Miller, Sandra Bensley, Don Walton, and some other dudes, right? Now, this bitch right here with the voice of a dirty, dirty stripper for 30 years worked as a Pima County Attorney's Office, where she was served in many roles, including Bureau Chief, Special Victims Bureau, and oversaw some cases in the Special Victims Unit. She's also worked with the community partners to implement programs to change efficient procedures for criminal processing. She graduated from the James E. Rogers College of Law. Don Walton also has been an attorney for 30 years, most recently in Maricopa County Superior Court as a judicial officer in family court and presiding cases, initial appearance court, and a criminal department. Prior to that, she served as an attorney primarily in administrative roles in juvenile law. She was an executive director of the Academy of the Justice of the Sandra Day O'Connor College of Law, and she has degrees in psychology, and she went to the Sandra Day O'Connor College of Law. So 30 years apiece, 60 years between the two of them for being judicial bitches, errand runners of the judicial world. 30 years of not producing anything and picking up a welfare check and just leeching off people. I mean, they've been 30 years of this. They have not produced anything, right? And now they get to put on a black robe and go out in broad daylight and fuck people over and over and over and over and over. And they could look at them. They've been overlooked for so long. I think at this point they're so desperate that they would do anything. They would fuck over anybody to keep wearing that black robe. Wait a minute. 30 years of doing nothing. Shannon got a master's from the university in 2021. And Don Walton was an executive director for the Academy for the Justice at Sandra Day O'Connor College of Law from 2018 until her appointment. Well, it appears that Shannon can not only get people fired, but she can get people hired, because this was obviously the master's class that she took in 2021, right? I mean, it's a course of conduct, right? Course of conduct. Who, might you ask, put these loose cannons in this spot that they're in now? All of whom were appointed by the judge that just denied justice to the entire world. It's no wonder there'd be no picture of her. But don't worry, we found one. Of course, I had to doctor it up a little bit just so you could see what it really looked like. For the cinematic effect, because this is just a story now, remember. She is also an alum of the James E. Rogers College of Law. So now, fast forward to just recent times, like 2 days ago. This bitch decides to have all his hearings and the 122 hearings and his so-called plea deal all on the same day, right? So some dude brought up in the comments that if she didn't pay the fee, then that, she's blah, blah, blah. Nah, dude, they appointed, look, so check it out. October 7th, 8th, 9th, 10th, whenever, October 10th, right, is when the fee would have need to have been waived for her to pay for the serving of the injunction. Check this out. October 2nd, right? Administrative order. In accordance with the Arizona Code of Judicial Administration, section blah, 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 fee deferrals and waivers, the presiding judge of the Pima County Superior Court, pursuant to ARS blah, 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 hereby appoints the following as special commissioners for the limited purpose of considering and determining applications requesting fee waiver, deferral of filing fees, and signing orders regarding deferral of waiver of court fees and costs pursuant to ARS 12 blah, blah, blah. What do you know? One of them's named Romero. It was stamped on October 2nd and in effect on October 7th, just in time for her to have that bad boy sent out. Anyway, you guys see how this works. Anyhow, moving on. And that story is over. Now the educational part comes in right now. So this is all educational now. Educational. So Rachel is given a chance to give the factual basis and then says, no, Mr. Myers needs to. And then Mr. Myers does give all factual facts about a factual basis. And then the judge lets Rachel jump back in and say these things. And now I just want to go over these and see how many of them are actual facts.
Your Honor, he engaged in posting Ms. Walker's information regarding her work email, her work address, her work phone number, and then he would put it onto his YouTube page, and then he put it up there.
Well, it wasn't posted, it was published, so scratch that out. And her information is so vague, we don't know what that means. But if she's talking about her work address, work email, and work phone, then nope, that's not true either, because the College of Law did that. And then he went on his YouTube page and put that out there. Well, I think more accurately, he took what was already out there that was put there by other businesses and other people, and he just took what was out there and reorganized it and then published it. I think that's more accurate.
He would encourage his followers to contact her, in which they did, and they left her harassing messages that
And this one really is confusing because you said harassing messages. I thought it was the number of messages sent by the person, not the content of the messages. And at least they were kind enough to just leave these messages. Unlike you put somebody in a box, locked them in a cage, and forced them to continuously read and write messages back and forth to you. So I think what you did is worse. Besides, wanting somebody to be raped and killed, that's just wishful thinking. By definition, that's harmless. You, on the other hand, Rachel, are actually harming somebody, bringing actual physical damage to their body and restricting their freedoms. My bad. I was supposed to be legally dissing these statements. Okay, so left harassing messages. Well, if they left the messages, then they didn't cause a communication. Because at that point, it's only a transmission. It's not a communication until it's received by another human being. So if they left the messages, then they are not causing a communication, which can't be harassing.
also ranges. That also range from things like wanting her to be raped and killed. And so these messages kept coming in. He was made aware of these messages. He's indicated numerous times that he was aware that his followers were reading these type of messages, and yet he continued to put up her information during this time and causing those followers to continue that contact with her. So he had initial contacts with her where he left her that message. He went to the law school looking for her, but then he also would use his social media to encourage followers to continue that contact.
Do you understand that all of that would have made her fear for her safety, Mr. Meyer? Okay. Then do you have any other reason why she would fear for her safety?
Because she doesn't understand that she's took an oath under ARS 231.
Taking an oath doesn't mean you have a right to be harassed,
I think harassed.
great fear.
The allegation other people did, not me.
So, but sir, if you're promoting them and
I
encouraging
didn't
them.
promote anybody and I didn't encourage them. There's no factual basis for me encouraging them.
Okay. Thank you, Mr. Meyer. At this point, I can't take your plea because I have a factual basis, and part of that is that Shannon Walker to reasonably feel for her safety or the safety of her family.
Did you hear this bitch? She said reasonably fear for her safety. She wants somebody else to tell her that somebody else is reasonably fearing for their safety. That is an impossibility on so many levels. Fear is an emotion. Emotions are literally, the definition of them is unreasonable. What a stupid thing to fucking tell somebody. And then she claims this is the fact. This is the reason that she can't accept his factual basis, is because he can't do something that's impossible. Because he can't tell her that somebody else is reasonably fearing. So Mr. Myers gives 8 minutes of rock hard facts. Rock hard, solid facts, not one lie in there, not one non-fact in there. And she can't accept his plea because he won't admit to the way somebody else feels. That would have needed to exist whenever there was charged, whenever he was charged. For the charges to exist, that would have had to existed. That is a fact that she needs. Not only is it not a fact, it's impossible to, even if you admitted to that or accepted it as true, you still couldn't not in any universe form anything to say that that's a fact. Even the person that is afraid for their life, that is in fear for their family, fear is an emotion, and it is unreasonable. Fear is an unreasonable emotion. You can't reasonably fear for something. Of course, the judge wouldn't accept the facts as the facts because they're facts. Because she was a prosecutor from 1991 until 2003, and then the U.S. attorney and a Pima County attorney, and she was an attorney in private practice, and then she was a juvenile hearing officer in Pima County Superior Court, and now she is, whatever you want to call it, the executive judicial monster that she is now. Okay, but even before this, we're going to work our way backwards now, right?
Said, I can do whatever I want. You know, I said, well, how do you overrule the Supreme Court? He said, well, I can do whatever I want in my courtroom. And if you don't like it, give a special action. But that's not really truly how it works. As we just saw here, 122 is the Supreme Court rule. So right off the jump, we were already, but I didn't want to go to a special action after the first hearing on a judge that's going to preside over my trial. So I let that one slide, and then, you know, a couple back and forth, he was refusing to give the bond hearing right from April 4th when it was initially filed. I know that I referred to it from May 12th, but this started April 4th. The initial bond hearing was filed by Parvin on April 4th. As of April 28th, he was still doing research. Well, what research do you need to do on a rule of procedure that's black and white? So that had us, you know, I don't want to say at odds, but, you know, we had a disagreement about the time frame of that, and he refused to rule on it. But then he had no problem ruling on a motion to dismiss the same day it was fully briefed. So he took, you know, 4.5 weeks to still do research on a motion for bond eligibility that's procedural right, and he took, you know, 4 hours to rule on a motion to dismiss that has serious implications for both me and defendants across the state of Arizona. He didn't seem to need to do any research there, so that got my radar up, and I told him that I would be following a Rule 10.
Okay, let's start right there. Okay, so I'm going to stop throughout and explain what I know about what he's talking about. Okay, before we get to the Rule 10, let's just go over what he just said, because what he just said is super important. Okay, I changed my mind. Let's hear what Rachel has to say to that first. Now, she's going to say no bond hearing, but she means bail eligibility, the same hearing that he was talking about having the disagreement in the time frame with.
In talking about the no bond hearing, there was no bond hearing held in this case. It actually took place over 2 days. There was testimony given at the no bond hearing. There were exhibits presented at the no bond hearing.
So it may be hard to tell what she's talking about because there's no such thing as a no bond hearing. Exactly like how on YouTube there's no followers, there's just subscribers. She's using a word that it has no connection to what she's actually talking about. It's not a no bond hearing. There's no such thing. It's called bail eligibility. But that's what prosecutors call it. They call it a no bond hearing, and that's how the judge she's talking to is going to understand it. And she wants to repeat it over and over, so that's what we, the viewers, hear and remember. So when we're looking over the agave or whatever, even the minute entries, that we're looking for a no bond hearing or whatever, and it will say no bond hearing, right? It's another way for her to get an extra couple weeks out of holding Mr. Myers off on his bail reexamination. Because see, if the judge holds it off for a couple weeks by calling it a reexamination of release conditions, and then he calls him out on it, then she can do no bond hearing before he calls them out on it. And that's now they got another month, dude. It's almost trial time before he actually gets to reexamine bail of eligibility. You know what I mean? But yeah, it's the same thing she does with the workplace info for Shannon Walker. She's like, he posted her work phone number and her work email and her work blah, blah, blah. Anyways, you get what I'm saying. And if you notice, they try to keep all the hearings on Fridays, so it can be like Saturday, Sunday, and then Monday before Mr. Myers gets the minute entries and sees what actually happened.
In talking about the no bond hearing, there was a no bond hearing held in this case. It actually took place over 2 days. There was testimony given at the no bond hearing. There were exhibits presented at the no bond hearing. So a full no bond hearing did happen. So Mr. Myers is referencing 7.4 when it transfers, but he's not indicated any change in circumstances warranting another review. I think he's under the false impression that this court is holding 2 no bond hearings every time somebody's held without bond, but that's not the case. It's extremely rare that after a first no bond hearing is held, that a second one is held, because there's usually nothing new that would be presented at it.
I'm not aware of any, are you, just because I obviously
I haven't, I'm sorry.
Now, all of a sudden, the judge knows exactly what she's talking about. Rule 7.4, whenever Mr. Myers was talking, she had to say, what rule is that? But now she understands everything, right? And she remembers every time that she's never seen it before, right? It's weird how that's when she decided to speak up, was on this specific topic, right? Where they're obviously fucking breaking the rules. Good job, Judge. You're a moron.
I just wondered if you were aware of any where no bond had a second no bond hearing. I'm not aware of any, but
No, I cannot think of a single case where somebody has had a second no bond hearing.
Dude, they are both playing stupid. Oh my God. I know you guys know it, but I just it's going to be hard for me to put this in words, but it's a form of confirmation bias. Like, check it out. So it's like cops do it all the time, dude. They're like the pros at it, but they'll be like, so like, you're confirming what they're saying by what their experience is, right? So they've never experienced, and because they've never seen it in their long years or whatever, then it confirms the fact that it's rare and it's probably not true or whatever. But the thing is like, the reason it's so funny to them, and the reason I can hear it, I can hear their little inside joke, because the reason that you would get it is if you were to change courts, right? If a defendant has held with no bond and goes to a different court, the prosecutor from the previous court would not. He would still only have the one the bond eligibility hearing, right? The defendant is the only person that would experience 2 bond eligibility hearings, one in one court and one in another. The prosecutor and the judge would never have 2, because it's because the reason you would get it is because you moved courts. You know what I mean? So they're sitting there like, they're both like, oh, I've never seen it. You've never seen it? I've never seen it. We've never seen it. Because you would never see it, because you're a prosecutor in a certain court. You don't, the prosecution and the judge don't follow to superior court and become superior court judges and different in the same prosecutor. You know what I'm saying?
Somebody has had a second no bond hearing. And in this case, he was indicted on the 2 felonies for which he was held without bond. So those 2 felonies are still in place and have been the entire time.
One CR, he has 7 felonies, and on the other one, he has 3. So I don't know what 2 she's talking about.
So I think he just has this, he sees it in the rule, but in Rule 7.4, it's not mandatory.
Oh, yes, it is.
It's not shall, it's may.
Which makes it mandatory. The word may means mandatory, right? When you have 2 options and you can only pick one of them, you shall not pick the other one, and you shall do the one you pick, right? So really, it's two shalls, not just one. It's mandatory, period.
It's not shall, it's may. And that's very different. And I think if there were some material circumstances that would warrant a no bond hearing, that could potentially happen.
He's doing it again, dude, because, dude, she's not dumb. She knows the rules inside and out, and she knows that this is a common way or a common mistake people make when trying to interpret it, because it is kind of a complicated way that they wrote it. But there will be no material circumstances that warrants whatever, right? And she's like, oh, I think if there were, then that might happen. No, there's no material circumstances, because the circumstances are in the rule. And that is if you write a motion, or if you don't, if the state just wants to do it. I mean, if the court wants to do it, there is no material thing that's going to do unless there is a different finding of evidence or whatever. But that's up to her, and that's not going to happen. Obviously, she knows that. So there's literally no material thing that could possibly make it happen, even though it can happen, unless you write a motion, right? In which case, it's mandatory. You may. Okay, I know I sound crazy. Let me just explain may, right? Because she said may, it's not may, it's not shall, it's may, right? Okay, let me start there. Okay, so may and shall are both group members of a group that are adverbs, I guess. Anyways, there's past, present, and future. And luckily for you guys, I memorized them all when I was like 7. This is mostly for retard Rachel, but here you go, you retard. So there's is, am, are, was, were, be, being, been, has, have, had, do, did, does, shall, will, should, would, may, might, must, can, could. Now, the ones that are important are may, might, must, can, and could. Well, shall, will, should, would. Okay, you're gonna hate this, but may and shall are the same. Kind of. So, it's like you shall suck my balls, right? You have no choice. You shall suck my balls, right? But may, there's always going to be a what was it, like not a criteria, like a check, like not like a checklist, but there's going to be factors, right? So may would be like, upon a clean sack, you may suck my balls, right? So if there's no clean sack, you're not. It's not that you may not, but you're not going to suck my balls. Now, so may in that respect is like shall, as long as it's not an option that you get. It's if the criteria is met through the sentence. If you come upon a clean sack, then you shall suck my balls. You know what I mean? It's not like if you come upon a clean sack, you get an option to suck my balls. You know, but now, in reverse of that, just like the word shall is meaning you will do something. You're going, see, shall will, you know what I mean? You will suck my balls. You shall suck my balls, right? So may and might is like it's the same thing, right? May and might. So like upon a clean sack, you might suck my balls, assuming you come upon a clean sack, right? You know what I'm saying? So, but now, if you say may not, it's the same thing as saying shall in the affirmative. It's like saying may not. Like, upon a clean sack, you may not suck my balls, right? So, even with no clean sack, you still may not suck my balls, right? So, if it says may not, then that's like the negative version of shall, right? But there will always be criteria in the sentence with the word may. It's a yes, I may is not. You can't end a sentence with an. Here's one your little brain might understand, Rachel. You may win at trial, but still be a loser because you cheated. But you also may lose at trial because you're a loser and you cheated, right? So no matter what, you shall be a loser because you cheated. You see what I'm saying? The jury may return a verdict of guilty or not guilty, but you shall be a loser and a liar either way. Now, this is for the rest of us that can cognitively use our brains to not cheat and put people in jail. If you replace, it's just like math. If you replace x, or you have an equation that has the answer and you replace the answer with a different number, then the equation should not work out, right? So you can do the same thing in verb tenses or adverb tenses with English. So, for example, the sentence is this. Generally, on motion or on its own, a court may re-examine bail eligibility or the conditions of release if the case is transferred to a different court, comma, if a motion alleges the existence of material facts not previously presented to the court or the defendant is unable to post bond due to the defendant's financial condition, period. The court may hold oral argument or an evidentiary hearing. So we're trying to figure out what the court's action here is to do because of certain criteria. So we start at the end. So the court may hold an oral argument or an evidentiary hearing. Those are the only two options the court has at the end of this, at the end of whatever. So those are the two options: oral argument or evidentiary hearing, one or the other. By definition, if it may do one or it may do the other, no matter what, it shall do one of those, right? So it's not giving you the option to may not. Like, it's not saying the court may hold an oral argument or an evidentiary hearing or do nothing. It's not saying that. It's you may do one of those two, but in the end, you have to do one of those two. So there shall is implied. If you do an oral, if a court may hold the evidentiary hearing, well, if that's what they want to do because of the criteria in the sentence, previous, then that shall be done. It shall be done. You know what I mean? It's not saying you may have the oral argument or the evidentiary hearing or just choose to do nothing. That's not what may means in this sense. To back up what I just said or double check what I just said, well, you can just look at any statute, really, because if there is a may not option, it'll say may not. So according to the rule, inaction is not an option. So the two options you do have, though, are the court can re-examine bail eligibility or the conditions of release. So I'm going to signify those by these words. Now, if it brings a whole new dimension to this whole thing. So these two things can happen if the case is transferred to a different court, if a motion alleges the existence of material facts not previously presented to the court, or if the defendant is unable to post bond due to the defendant's financial condition. So basically, if you go to a new court, you get some new evidence, or you are broke. Bond. Okay, so here's what you're looking at. Any one of these is possible. You can examine the conditions of release if you have a transfer to a new court, or if you can't post bond, or if there's new evidence. You know what I mean? Release can be any one of those, right? And then same thing with eligibility. You can re-examine eligibility if you can't make the bond, or if you go to a new court, or if you have new evidence. Every one of those is precursor or whatever by the word if, meaning they're all options. So what dictates if that's going to or how that's going to happen, and which one is going to be the oral argument or the evidentiary hearing? Well, it's dictated by either the motion or the court, right? So if there's a motion for an evidentiary hearing to re-examine bail eligibility for whatever one of those reasons, then the court must have that evidentiary hearing. There's no other way to diagnose it or read it. You know what I mean? Because remember, the court's only two options are to hold an oral argument or an evidentiary hearing, right? And so if there's a motion to re-examine bail eligibility, you're not going to have an oral argument to decide if there's a motion for re-examination of bail eligibility, right? You're only going to have the oral arguments if it's just to discuss the conditions of release, right? So it's not saying that on a motion for re-examine of bail eligibility, you have you set a hearing for an oral argument about if you're going to get the evidence, or if you're going to get the reexamination for bail eligibility, because at that oral argument, if you win, you're going to get the evidentiary hearing, which is already an option, thus giving you both, which would defeat the whole purpose of having or on there and having options, right? So if there's a motion for reexamination of bail, then you shall have to 100% are going to hold the evidentiary hearing, because otherwise the word or, and it just undermines the whole sentence. It just makes if you do both and you do it the way Metcalf wanted it to be done or thought that it should be done, it doesn't make any sense. The sentence is moot. All the words in the sentence become nothing. The judge could just not do it. The existence of the rule and those two sentences means that the judge can't do what he's trying to do. Like its very existence means that the judge has to follow either one of them or the other one, depending on the motion. You know what I mean? Or he can do it on his own in absence of the motion. But the existence of the words are the reason that he can't do what he wanted to do, and the very same reason that this judge, this whatever Lewinsky, should have followed what Lane said. So here's how we know that she knows. But first, here's the rule, so you can see it. On motion or on its own. This is only two sentences. So on motion or on its own, comma, a court may reexamine bail eligibility or the conditions of release if the case is transferred to a different court, comma, if a motion alleges the existence of material facts not previously presented to the court, or the defendant is unable to post bond due to the defendant's financial condition, the court may hold an oral argument or an evidentiary hearing. So those are two sentences. I know it's confusing, but here's how we know that she knows what the deal is. Because the state, here on number 3, it says eligibility for bail. If the motion is by the state and involves a defendant previously held eligible for bail at the initial appearance, it need not allege new material facts. The court must hold a hearing on the record as soon as practicable, but no later than 7 days after the motion's filing, right? So you see how when the option is gone, it becomes a must. And even if the option is there, you must do one of them. You see what I'm saying? So there's no way that she can follow that rule and not follow the one above it or comprehend the one above it. Now, here's how we know that she followed that rule. Because remember, I've said this 400 times, but she only uses the right nomenclature when it benefits her. And in this case, for her to use that rule, she needs to. So it would benefit her to use the right nomenclature. You know what I'm saying? So remember, bond eligibility, the state's got 7 days. Look here, 3/26, and exactly 6 days later, 4/1, they have the hearing. This is the one the no bond hearing, she's calling it. So this is the one where she's presented all the evidence, right? The only one she presented evidence. It went 2 days. Well, she's calling it the no bond hearing, and she's going to try to drill that into our heads when really it's the bail eligibility. Like I just showed you, she uses it when it's good for her to get to her 7 days or whatever. But when it's time for Mr. Myers, she calls it the no bond hearing, and she wants us to look at it as the no bond hearing. And watch her work her magic. The fact that she's reading the words the way they are written means that it must be done that way. I don't know how to explain that to somebody.
Motion to strike
How did somebody get the exact same math equation that they've been working on for 50 years exactly wrong the exact same way at the exact time and have an understanding that it was exactly wrong in the same way? Like it's so pinpoint wrong, and there's only you can only misunderstand something so much, dude. But the fact that they both do in the exact same way without even talking to each other, it means that they're complicit in its obfuscation.
And so that's regarding speedy trial. I think Mr. Myers just doesn't fully understand there's this the time limit for speedy trial to get the case to trial. But then there's a whole separate time frame for sentencing that has its own speedy trial, per se, under 26.3, where it has a separate time where it's mandatory when the sentencing. And I think Mr. Myers just may not understand there's actually 2 separate time frames for that.
Let's see what he may not understand here. Let's see if I understand here. Let's see if you understand. Okay, this is the way I understand it. There's 2 time frames, right? Did I get it so far, retard Rachel? Did I get it? 150 days and then 30 days for sentencing. Did I get that right? Okay, let me see. This is what you think. Did I get that right? 150 days plus 30 days for sentencing. That's what you think. Now, Mr. Myers thinks that with sentencing, it should still be. Did I get that right? Did I nail that one? Huh? Did I do it right, Rachel? Retard.
But regardless, the date for the trial in this case is set well within speedy trial time, as I noted in the motion. And so there's nothing in this case that's indicating that Judge Metcalf has any bias.
Nothing at all.
Hearing within 7 days. He took it to, so the motion gets filed April 4th. As of April 21st, he was still doing research to decide if he was going to have a hearing, No, that's not the rule. That's not the case law. The case law is clear about this, that it's a matter of right. You file the motion under Rule 7. When there's a change of court, the court was changed. The de novo standard is re-examine means renew. Just, the Court of Appeals has defined what they mean by re-examine. That means a de novo review. So the only way you can de novo review somebody who's not eligible for bail as a matter of right is to have another evidentiary hearing, because you're
Mr. Marks, just so I'm sure, which rule are you referring to?
7.4C.
Okay.
Yeah. 7.4C. It says that if the
Oh, which one are you talking about? 7.4C, the one that me and Rachel just had a little joking laugh about? Ha 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 ha. And now I don't know what it is? Fuck you, bitch.
on a motion, the court on its own, sua sponte type thing, or on motion, can re-examine bail eligibility. Well, the plain meaning of bail eligibility, everybody's eligible for bail as a matter of right, except people who are not eligible have been held not eligible for bail as a matter of right under the 7.2, presumption, what is it called? You know what I'm trying to say, where they find proof evident or whatever, you know what I mean? At the initial hearing, they find that, and then you still gotta be indicted though. So that you have the initial one, you still gotta be indicted in the Justice Court, it gets brought over to the Superior Court, and you can move to re-examine bail eligibility. Well, the plain meaning of bail eligibility is, you're not eligible, or you're eligible as a matter of right. Everybody's eligible except this limited class of people that get found proof evident. So right there, he said, well, that's not how I interpret it. Well, there's no other way to interpret it when the Court of Appeals has made it clear that the word re-examine in that rule means de novo review. Well, de novo means you throw everything that happened away and you start over. To start over for somebody who's not eligible for bail as a matter of right is to have another evidentiary hearing. It's right in the case law. And I realize we're not arguing that motion right now. Which I've been trying to do for 7 weeks now. I've been trying to argue this bail motion, but I'm being held with no bail and denied the chance to argue why I should get bail. The state should be forced, because the things they held me for, one of them didn't even get indicted it got indicted as a misdemeanor. So their whole you're being held for these felonies. Well, one of them is a misdemeanor now. So I should get a chance to re-examine bail eligibility, the plain meaning of the word, and then the case law says two reasons you can do that: transfer to new court or new material facts. I was transferred to a new court. I applied for a bail eligibility hearing. It's a re-examination. Re-examine means de novo. Well, we got Metcalf going, well, I don't really feel comfortable looking over Judge Miller's shoulder. Well, no, that literally by rule, procedure, and controlling case law, that's exactly what you need to do. You need to take what Judge Miller did and set it over here, pretend it never happened, and start from scratch. De novo, review anew, start over, de novo review, they start over. That's what that means. So he's letting the state file, like I said, a recipe for apple pie, and saying, oh, well, your motion's denied because the recipe for apple pie says you don't get another hearing for bail. And that's right there. That's intentional disregard for the rules. That's not being impartial. That's being biased. That's being prejudiced against me. He's not taking my argument serious because I'm pro se. There's no other defense attorney in this court, no other judge in this court, no other defendant in the state of Arizona has to wait 7 weeks for a bail reexamination. That's a procedural right. It's a procedural right. It's not even something the state can argue against when it's a procedural right. You have the right to this re-examination. It's not, oh, well, we'll decide if you have the right to, we can file a motion and you can ask. No. You file the motion, you get the hearing. It's that simple. That's one thing. Now, the denial of the speedy trial, when he was setting the trial, I said, Your Honor, you have to set the trial in enough time to have sentencing before the speedy trial runs out. He says, no, you don't. No, you don't. That's not how it works.
And what rule is that?
That's case law. It's in my motion. It's case law. It's in my motion right here. Speedy trial. Right here. That's State versus Bartlett, 179 Arizona, 109, 876, page 2D at 114. Court of Appeals, 1993. In light of the foregoing authorities, we hold that the guarantees to speedy trial found in the Sixth Amendment of the U.S. Constitution and Article 2, Section 24 of the Arizona Constitution apply through sentencing. So him saying, no, it don't,